Great. Good afternoon, everybody. Ryan Wozniak here again at Peninsula Canada for our weekly Facebook Q&A live session. Welcome to everyone in attendance. Nice to see you again. For those of you who are returning, wait for people to log in and start asking some questions. I'm just going to keep an eye on the attendance total here before I get too far into today's session. So everyone has a fair opportunity to participate and ask questions. Again, for those of you who are just now joining us, it's Ryan Wozniak here again at Peninsula. I'm here for our weekly Q&A live session and our weekly, I'll call it fireside chat. If anybody has any questions whatsoever relating to COVID-19 and how it's impacting their business, I'm here today to answer those questions and work with you to find some solutions. And I know a lot of you right now are focusing on returning to work and have questions about how best to do that and what some of the challenges and obstacles might be in that respect and how you might overcome those. So by all means, ask away today. Happy to talk with you all over the next hour. And for those of you who haven't done this before, there's a little box on the left of my screen that lists all of the questions that people are posing or asking of me, and I'll read them out to everyone watching and provide my answer in real time. So don't be shy. And as I said earlier on, feel free to ask me any questions that you have relating to any HR challenges you may be experiencing, particularly in light of COVID-19. And I know this week we're focusing on return to work and how employers can prepare to reopen their doors over the next few weeks or now, depending where you are within your own enterprise. And as I keep saying, don't be shy. Please ask away. Whatever questions you have, they'll come up on my screen here in real time, and I'd be happy to answer them for you. Okay, I think we have 7 or 8 people in attendance now. So for those of you watching, again, if you have any questions, please ask away. Question, I'm having trouble enforcing my staff to wear PPE. Is there something I can or should do? Well, obviously, if you're reopening your business and you're complying with government guidelines and safety guidelines, or even implementing your own safety procedures as you have staff re-enter the workplace, those requirements, those are requirements that staff will have to abide by. So if you are implementing safety procedures that are necessary to ensure that your workplace is not going to expose your employees to harm, then they will be required to comply with those requirements in furtherance of and in compliance with your own health and safety protocols and their own obligation as employees to ensure their own health and safety in the workplace. So if you've implemented safety procedures, communicated them to your staff, and have trained your staff on those procedures, and they refuse to follow them and they're necessary to ensure their health and safety, then that can be grounds for discipline. So again, any other questions, folks? Whatever's on your mind, this is a open fireside chat this afternoon, as it is every Wednesday. Whatever you wanna bring to the table or ask me, don't be shy. Again, we're talking a lot right now about return to work and what that's going to look like for employers and what some of the challenges, what are some of the challenges that they're going to face. We have been reading a lot in the news lately about employees not wanting to return to work because they feel it is unsafe. And that's an interesting question. What is unsafe, and when will an employee be justified in refusing to work, and what can an employer do if an employee refuses to work and that refusal is unjustified or unreasonable? What options does an employer have in that situation? Okay, I have a question. I have several staff that attended a large gathering Saturday. I can't prove it, but the other staff know and don't want them coming into work. I think that there are no hard and fast rules around this. And there's no specific rule or law or principle that says if an employee does X outside of work, then the employer must do Y. It's always a challenge trying to limit or control our staff's behavior outside of the workplace, especially when they're on their own time. And there are limitations. Um, but in a situation like this, I mean, I don't know what kind of information you have, what kind of gathering these people were attending, how many people were involved in this gathering, and where it was. Were they at Trinity Bellwoods Park? I don't know. As an employer, your obligation at the end of the day is always to ensure and take reasonable measures to ensure that you're not exposing your staff to unsafe work conditions. In this case, your concern is obviously that these people might have interacted with someone who could have been exposed to COVID-19 or may even have the virus and may be asymptomatic, for example, and could then bring that virus or that infection into the workplace. If you're seriously concerned about this, again, I'd probe for more information. Now, again, I don't know what type of business you have and what your social distancing procedures are like within your business. But if you're clear with your staff about what the expectations are, that if they're going to come into the workplace, they have to honor social distancing requirements outside of the workplace, and that's reasonable for your workplace. And you have reason to believe that these individuals could bring a risk into the workplace, i.e., a risk of infection. I think you would be justified in saying, I think you better self-isolate for 14 days. And by the way, our policy is that in order to re-enter the workplace to ensure it's safe, you need to acknowledge and confirm that you've been abiding by social distancing requirements as mandated by the government and as part of our current lockdown order. Okay, it's still early on, 12:08. We've got some people in the room. Any other questions that people want to share or ask? Perhaps some of you have encountered circumstances or situations where employees are refusing to come back to work. I know that's a question or an issue that's come up quite frequently in our discussions with clients over the last little while as people begin to reopen their enterprises, their businesses, their workplaces. Um, there is a process, and I think it's an important conversation. Some of you out there might be looking to recall staff from layoff, or alternatively, maybe looking to permanently sever the employment of individuals that you can't bring back, and there's a process for that. Okay, another question. Several of our staff have now returned to work, but morale is really low and fear is high. Is there a way I can properly discipline poor background conversations between my staff? I guess this question is more of a practical one than a legal one. I think it would be practically difficult to discipline an employee for what we might call or could possibly describe as unhelpful behavior. or toxic behavior or gossiping. Because the reality is, it happens all the time. And I suppose it would be open to you as an employer to include something like that in your own internal HR policies, whether that legally, whether you would ever be able to fire somebody for cause, successfully dismiss somebody for cause if they were to violate that policy. That's probably tough to do. I'm not sure that would meet the high bar required for cause. I think, practically speaking, it's important to communicate a positive message to your staff and to emphasize what you are doing as an employer to keep your staff safe, why it's appropriate and why it's working, and highlight the successes of those policies to your staff routinely. Staff will rally around the positivity and the assurance. And when employees, I think it's trite to say that when employees see that their employers care about them, that they're taking steps to ensure their safety, and they're reinforcing that message, and they're having conversations with staff who may be naysayers, that it will have a net positive impact on your employees. And after a while, they might say, why, I don't know why you're complaining so much or why you're being such a naysayer. Look at all they're doing for us to keep us safe. People will, you can't deceive them, but if they see the actions that you're taking in the flesh reinforced by messaging and enforcement of those safety protocols, your staff will believe in what you're doing. And it'll be a lot harder for someone to try and plant that negative seed in their coworkers' heads. But I do think it's worth a conversation with your staff. I do think you can go to someone and say, look, we don't appreciate you trying to undermine, whether deliberately or inadvertently, what we're trying to do here to reopen our business and keep our staff safe and confident. It's not helpful, and we don't appreciate it. And if that continues, you might be in a position where you might be able to let the person go without cause. If you feel that person is causing too much trouble, you could let them go without cause, and that would be provided you give them adequate notice. But that would be an option. Okay. There's been a lot of talk in the news about working from home, or the new working from home normal. We don't want our staff working from home forever, but now they're pushing back on the suggesting everyone else is. So we should be able to. Can we let them go if they refuse to come once we return to the office, or return to come in once we return to the office? The short answer is that that could be the case. An employee who's working remotely now because of a shutdown order, who's now being asked to come back to work when the business reopens, is expected to come back to work unless there are some extenuating circumstances that inhibit their ability to do so. So, for example, and you're going to see this a lot, work refusals, employees saying it's not safe to come back to work. And a lot of employees are saying, I've been cocooned in my house. Really, I don't want to go back to work. I'm safe here. I'm not ready to come back. I don't feel comfortable. Well, that's not going to cut it necessarily, because a work refusal has to be reasonable. An employee's fear has to be reasonable. Walking out of your house and saying, or being fearful of walking out of your house and getting hit by lightning, it's not reasonable. It's possible, but not reasonable. However, if your employee goes back to work and realizes that you're not taking, as an employer, not taking any safety precautions, you don't have any policies and procedures or PPE or anything in place to ensure the safety, and they walk out and say this isn't safe, well, they might have a case, and you'd have to deal with that. But it's not, or perhaps they don't have childcare and they need to invoke a statutorily protected leave, or they require some form of accommodation because they don't have access to childcare with school closures being in effect. But an employee can't just say, I'm not coming in and I'll come back when I'm ready. No. You're in that situation and you make reasonable requests, and the employee has no justified objection, that can constitute a job abandonment, and it could give rise to a separation of employment with no obligation by the employer to provide any pay to that employee. However, you want to make sure that you talk to an advisor before you go off and do something like that, so you don't put yourself at risk of being in a termination situation or wrongful dismissal situation where you could owe some common law damages to the employee and end up paying them out for the grief that they've actually caused you. So you can do it, but it's got to be done right. Okay. Oh, thank you. Awesome. Thank you. Thank you for the thank you. Hope you found those answers helpful. Um, just scrolling down my list, seeing if anyone else has any questions, please, again, fire away. We still got another 45 minutes here. Another question. I'm reading a lot of reopen emails from other businesses that have not been cleared to open, but they're talking about the precautions they will be taking. Where are they getting this information? Um, not sure. I guess what I would say about that is if a business intends to reopen, one, make sure that you're actually able to reopen. You're still not subject to lockdown orders. And two, make sure that you're complying with all of the industry-specific, sector-specific government guidelines, and also that you're doing all of the necessary things from an HR standpoint that you should be doing to reopen, like updating your health and safety procedures, communicating with your staff, training with them, making sure that you've got a recall plan if you're bringing people back off of layoff, etc. Next question I have is, do we need to accommodate, I'm assuming an employee, if they are high risk due to underlying health conditions? And it sounds to me like these underlying health conditions could be disabilities, and if so, then ostensibly yes. I guess it depends on the reason they require accommodation. So, for example, if someone's being recalled to work and they are in an environment where they'll be exposed potentially to a lot of other people, even if there is social distancing, and they might have asthma or a pre-existing health condition that could put them at greater risk of being uh, seriously ill if they contract this virus, then yes. But accommodation cannot be viewed in a vacuum. Accommodation is extremely contextual. So it depends on the nature of the illness and the nature of the workplace and the nature of the work. And generally speaking, if someone invokes a co-protected ground and wants protection, right, then an employer has to, not generally speaking, the general rule, I'm sorry, is an employer has to accommodate that disability up to what's called the point of undue hardship. Now, the point of undue hardship is not a hard and fast rule. This is where the context comes in. It's a very context specific, business specific analysis to look at, again, can the employee's job duties be modified? Can their schedule be modified? Can they maybe work remotely doing what they do for a certain period of time until we have a greater understanding of how infection rates are going to play out, et cetera? Okay, again, something you'll want to talk to an advisor about. It is a line by line analysis and very tricky to do, almost impossible to do in a vacuum. Okay, but a very good question and something that employers need to be very aware of right now, because you're going to get a lot of these requests, whether it's childcare, family status, disabilities. People are scared and they're going to try and find reasons not coming back to work. And some of them might be legitimate. As an employer, you've got to be prepared to deal with them and make sure you don't run afoul of human rights legislation or even health and safety legislation. Okay. Next question I have a staff member who claims they're going to proceed with a wrongful dismissal. When do you think these proceedings will take place? Interesting question. That's Our courts right now are still more or less closed. You know, they are operating and they're virtual hearings and discoveries, but nothing's happening quickly. So if employees start bringing lawsuits, if you're talking when will you get a hearing on the merits, a trial or a motion? Probably not for a long time. Right now, it's more likely that parties will go to an out-of-court mediation. If you sue in certain jurisdictions in Ontario, there's what's called mandatory mediation. For example, in Toronto, there'd be a mandatory mediation, and that's basically a settlement meeting, court mandated or system mandated settlement meeting that's presided over by or facilitated by what's called a third party neutral mediator. Okay, and that's where a lot of litigation that does start now is going to end up. for the next little while. People are pursuing hearings on the merits. A lot of social justice tribunals are their dockets are going to be backed up perhaps to 2021. I'm sure of it. So absolutely, the courts are slow in the best of times, and all this pandemic has done is slowed them down even more. It's molasses in winter at this point. So that could be advantageous for employers because litigation won't move quickly. Um, but if you are seeking relief as an employer, you might have a claim. It can be very frustrating. Next question I have a longtime staff member that is asking me to keep them on layoff because they do not have access to childcare. However, this person is the only person that I employ who can do that specific job. Can I keep them on layoff, hire someone else, and release that person before their probation is over to bring the long-term employee on layoff, to bring back the long-term employee on layoff? We'll unpack this question. So a couple of issues arise here. If this person's on layoff, um, and you want to bring them back and they can't, what you could do is they could effectively come back and they would immediately take a statutorily protected job, unpaid stat protected job leave, while they sort out their family situation. And they might say, "Look, I'll come back to work when I'm able to." Now, you could temporarily replace that worker, but if it's a job protected leave, then generally speaking, an employer can't fundamentally alter the terms of that employee's employment. You can't fire them. That's why it's called job protected. Change the terms of their employment or eliminate their job. However, there are circumstances where a bona fide restructuring could eliminate the role. But if you try and eliminate the role through, or say you're eliminating the employee through the guise of eliminating the role, and then you give someone effectively the same job with a different title, you could run into trouble, and could be a reprisal order made against you by the Ministry of Labor, et cetera, if it's in Ontario. So you have to be mindful of that. But if someone invokes an accommodation, or requests accommodation because of their childcare, which is a different option technically. You see, I require accommodation because I've got childcare responsibilities, which are code protected. You talk about accommodating up to the point of undue hardship. Um, how do you find someone else to do that job? That's the only person who can do that job. How can I accommodate that if you're the only one who can do it? I don't know enough about the circumstances or particular job duties in question. I guess my natural response is, well, I wonder if there's got to be someone who might be able to do some aspect of that job, or maybe as a business. Now, this is when we get into the analysis of undue hardship. Do I now have to hire two people who might have part of the necessary skill sets required to do that one job, and now it's going to cost me double the salary? Can I accommodate it? But that's the only person who can do the job, and you want to get rid of them. Who's going to replace that person, right? So again, I don't know enough about the circumstances, but these are the types of conversations you need to be having, preferably with an advisor as you work through these issues. Okay. Next question I have. I am looking at hiring staff. I am unsure of having work from home and recall in my documentation. How would I go about this? I think if you are going to hire new staff, it's number one, a great opportunity, if you're not doing so already, to utilize proper employment contracts with enforceable termination clauses and most definitely layoff rights and change of duty clauses. You want to give yourself as an employer, especially nowadays, the contractual flexibility to adjust an employer's duties or an employee's duties if you have to, because we just don't know what's going to happen in the next 6 to 8 months. There could be a second wave, so we might have to bring people back or hire someone, and then we have to lay them off. And we want to make sure we have that contractual right, because some of you may know, an employer does not have a standalone right to lay an employee off temporarily. It has to be contractual. There has to be a contractual right to do that, contained in a written employment contract between an employer and employee. Okay, if you don't, it technically can be constructive dismissal. So it's a great opportunity if you're hiring someone to say, hey, no, I'm going to use a proper contract this time. And if I have to lay that person off because there's a second wave and now there's an unforeseen disruption in my business, great. Now I've got that contractual right. covered off. I'm not exposed to a constructive dismissal claim. Right? Secondly, if I then have to migrate to remote working or consolidate job duties or job functions in order to free up cash to run my business and or whatever I have to do, I have to move the pieces around the board to make it all work. Okay, you've got that contractual flexibility with the specific contractual terms contained in an employee's employment contract envisage changes to their duties and roles as the needs of the business change, and the employer can do that. And there's language to the effect that the employer will be able to do that in its sole discretion as the needs of the business change, et cetera, et cetera. And I think in this current environment, if that were ever litigated, employer would probably be given some latitude because they're trying to keep their lights on and keep their business going and ultimately employ people, which is in everybody's best interest. Okay. Next question. I am wondering if PPP is essential protection for food handling. We're currently enforcing a mask policy for kitchen staff and face shields for those up front with a plexiglass shield for the cashier. Um, Customers are coming, outside are coming to the door. I've been looking online for the requirements when it comes to cover, and I haven't seen info on the City of Hamilton, Ontario website regarding masks. Definitely wanting to ensure safety, but also helpful to know if it's essential or not, since someone is spending hours in front of a hot grill. Okay, big question there. Look, the starting point has to be the industry-specific guidelines. I don't have them in front of me at the moment on my computer, but if you go to the Government of Ontario website, I think if this employees in Ontario, I'm not sure which jurisdiction you're in, whatever the relevant, whichever province you're in, check your government's website, and there'll be a list of return to work requirements and sector-specific guidelines. You want to make sure you start with those and make sure you're complying with those. Baseline, PPE for sure. You know, if you're in retail, plexiglass at the counter is a no-brainer. Gloves, masks. Okay, how you adjust your specific PPE requirements or protocols to suit your specific business is another matter. Okay, so you want to make sure you're following whatever government or sector specific guidelines are out there. But there's another layer to that conversation. You as an employer might have to take it to another level because there are other aspects of your operation that require modified or maybe increased protections. And so, again, this is where working with an advisor is so critical. Sitting down and saying, okay, here's my business, here's how I do things. I know I've got these government guidelines I have to follow, but what more should I be doing? And really, health and safety in a lot of ways is common sense. Okay, and you want to make sure that you're looking at the situation not from okay, I've got a checklist now, I've done all these things to a point, yes, but you also have to take it to a more to to a more detailed level, I guess I can put it that way, and making sure you're kind of walking through your operation and doing a conceptual walkthrough and making sure, okay, at this juncture, I'm going to need increased PPE because, you know, masks are fine, but I can't have, if I'm on an assembly line, I can't have people in plexiglass boxes doing their work. What am I going to do? I spread people out? Do I use gloves? Have different kinds of PPE? These are multifaceted questions, and again, really important to work with an advisor and drill down at the micro level. Okay, next question. Does the amount of notice for termination vary depending on employment service length? Short answer is yes. There is, these are called the Bardol factors for those of you who are interested. This is, there are certain factors a court takes into account when assessing an employee's notice period in a without cause termination situation, one of which is length of service, sort of the four main ones, the Bardol factors: length of service, your position, what you were earning, and the likelihood that you're going to find new employment reasonably soon. There are more factors, but those are the big ones. So yes. Oh, I should add, so generally, the general rule is the longer your period of service, the greater your notice period. The rule of thumb, if I can say it, that courts hate when lawyers say this, but the rule of thumb really is in practice, you're looking at about 3 to 4 weeks of pay per year of service in a without cause termination situation. In terms of those would be what are called employees' common law entitlements. Okay. You're welcome. You're welcome. Another thank you. Thank you. You're welcome. I hope that was helpful. Um, and we're coming up on 12:30 mark, but we've still got another half hour for Q&A. So again, don't be shy. Um, please do ask your questions. The ones that you've been asking today are so thus far been very relevant and very interesting. I'm always curious to hear how employers are dealing with this, and I can tell you as a lawyer, it never ceased to amaze me the creative problems that employees can throw at employers. Um, Next question. We're looking into creating checklists for staff once they return that covers what we have done for PPE and what the responsibilities are of our staff, social distancing, etc. Is this something that we can display, or should we also send it out? I think well, as a best practice, I think you need to do both. I think whatever health and safety protocols and procedures you put in place, you absolutely have to document them, communicate them to your staff, give them copies, train them, and post them. And some provinces in British Columbia, you have to post in Alberta, I think you do too. You have to post um, your health and safety protocols, and I think it has to be posted in a public place so that the public can see what you're doing and knows what to expect when they. The idea is when a member of the public goes into a business, they want to be assured that it's safe. Okay. But as a best practice, I mean, I know the government tells us to do this, but why wouldn't we want to do this as a best practice as a business? Why not? And we're doing everything right. Look, Joe Blow, member of the public, we are a responsible employer. We are a good business. We take care of our staff. We're taking all reasonable safety precautions. Here's what we're doing about it. This is why you see our staff members wearing masks and plexiglass. See, it's safe to come in here. It's ultimately better for your business, right? It's safe to come in here. So come into my store and consume my goods or consume my services because you don't have to worry. So now, of course, you want to protect the public, but you also want to protect your business in as much as you want to make it attractive to the public. You don't want to have a store open where people look at the window going, there's 50 people in there, no one's wearing a mask, people are shaking hands, it's a big party. Whoa, I don't think I'm going to go in there. It doesn't look safe. And after a while, won't be that many people in your business, I would assume. Okay. Any other questions? A return to work, any employers having issues with employees refusing to come to work? We talked a little bit about childcare, but saying, look, I don't want to come in, it's not safe, I want to stay at home. You can't make me come back to work, or some employees might want to stay home and continue collecting benefits rather than risk going out in the big bad uh, world. And what do we do about that? You can talk about that if you want. Just gonna have a sip of water. My throat's a little bit dry from all the talking. Okay, anyone? Okay, again, we've still got 25 minutes. We're here till 1 o'clock. So, um, again, ask away. And by the way, I guess I should add, just while I've got some dead air time here. Oh, quick question. All I was going to say is that I know that people are always afraid, employers are always afraid about what the authorities can do to them if their policies or processes are, inadequate, or are they going to be compliant with health and safety legislation. And I know that we might have read as well that in Ontario, in particular, the government's hired additional, many more Ministry of Labor inspectors because I expect there'll be a lot of disputes over uh, work refusals. But we have to bear in mind that this is uncharted territory for everybody, employers, employees, and enforcement agencies, the government. And I think employers to bear in mind that the Ministry of Labor is not always coming in with a stick to bash you over the head and say, you terrible employer, what were you thinking? They're coming in to learn. Government's still learning, just like we're all learning. How is this going to play out? Are these guidelines working? Do we need to change them? Do we need to make them more stringent? Do we need to relax them? Do we need to change them? What are we seeing on the ground? So remember that this is largely an ongoing learning process for all of us. Every day is a school day. So I know it's tough to make decisions. You want to tick the box and say, okay, you know what? I'm just going to follow the rules. I'm good. All of us have to remember that this is a dynamic, iterative, organic process. That we have to make tough decisions on the fly. We have to use our judgment, our common sense, and also work with advisors to make sure that those decisions aren't going to run afoul of any applicable laws or government ordinances. Okay. Um, I have a question here. We are now open a storefront and we are having issues with customers not respecting social distancing. Our staff are concerned, but we're just not sure to respond to customers. Um, well, look, this is an interesting question. So is the front of my store the workplace? I don't own it, but is it the workplace? Do I have control over it? I'd say if you have storefront pickup and you have people working outside and you're managing the little area, probably say that you do. And in that situation, I think you're perfectly within your right as a business owner to say, look, there are rules around social distancing. Customers, you need to stay 2 meters apart. I've got markers on the sidewalk. I've asked you to stay apart without being a total jerk. But it's very, very important that to ensure our own worker safety and your own safety, that you honor these requirements. We will get to you, I promise. We've got what you need right here. We will get to you. It's going to take a little bit longer. I apologize, but we will get to you. And if there's anything, any questions you have, and put on your customer service hat, and and you will always have people who don't care, and don't be afraid, um, to stand firm, to stand firm on those rules, because you don't want other people to get spooked and run off, or I know everyone's worried about people reporting them as well. As long as you're doing everything you reasonably can, that's the test. Am I taking all reasonable steps to ensure my worker safety? Employees will appreciate that, seeing you taking, you know, taking action with customers. Customers are always right, but not when not if it involves endangering our staff. Okay. Um, Next question I have is, we have several long-term employees who have not enrolled in our benefits program despite being given multiple opportunities. Can we have them complete a letter stating that they are refusing to enroll? Um, I guess I don't know what your contracts or benefits, or what types of benefits these are for. I guess it's a group benefits plan. Um, I guess if an employee doesn't enroll in their benefits, then they wouldn't be entitled to receive them. I don't know if that would be enough to discipline them and fire them. You could get something in writing confirming that they haven't enrolled and notify them. So if down the road they ever got sick or wanted to make a claim against that benefits plan, you'd be in a position to say, no, you never enrolled. I'm not sure why they're not enrolling. Maybe they have their own private benefits. I'm not sure. And without more facts, it's tough to say. But what you're looking for is confirmation. So if there's ever a dispute, you have papers. I think that's a great idea. Um, Next question. Do you know if there will be any flexibility in the Labor Act around break time? If an employee agrees, can we have them work a compressed day to prevent people from leaving on a break, returning midday, or restrict where people take breaks? Um, or I don't know. I'm not aware of any information or in plans by the government to amend, if this is Ontario, the Employment Standards Act, to adjust the rules regarding break times. In Ontario, an employee, I believe, has to have a break every 5 hours, generally speaking. and you can't contract out of the act unless you provide a greater benefit, which is always a difficult question when it comes to breaks and what is a greater benefit than having a bit of a rest. Um, I think that employers, though, beyond that, are within their right to set schedules that are going to work for them and are able to set employee rotas and other workforce planning measures and structure them in a way that are going to allow their business to function optimally. And as long as you don't run afoul of the Employment Standards Act, you can schedule your staff to work however you want, as long as you account for break times and the limits on total hours worked in a week and overtime and the rest of it, which can be complicated. Don't want to oversimplify it. But if you want to compress an employee's day, I don't really know what that means in this situation. But again, you have that flexibility. As long as you don't run afoul of the act. Next question, what if there are certain employees we don't want to call back to work right away or at all? How do we go about that if we can or can't? Two, what if we had to change the employee's duties due to the needs of the business right now and they refuse to come back with those new job duties? Great. This is a great question because it really touches on some really key and important considerations that and risks that employers are going to have to address as the dimmer switch goes back up to on and we start to go back to work and we call our employees. So to answer your first question, if you have an employee on layoff, one, you better be mindful of the statutory limits on the length of layoff. If you eclipse those limits, then you're in a deemed termination situation. Employee may not realize it, but if they ever lawyered up or did their homework, they'd say, wait a minute, I've been dismissed and I want termination pay. And a deemed termination could trigger an obligation on the part of the employer to provide both statutory and common law termination pay. If you decide that someone on layoff is going to be permanently laid off, i.e. dismissed without cause, that's going to trigger an obligation as well to provide the employee with statutory and common law termination pay, unless they've signed a binding written employment agreement that contains a specific termination clause, an enforceable termination clause, that enables you as the employer to limit their termination pay to something less than the common law maximum. So it could be any amount that's not less than the employee's statutory entitlements. If you don't have that contractual protection, then you're exposed to a common law claim, which could run you up to 3 to 4 weeks of pay per year of service, subject to obligation to mitigate. And the rest of it, again, very important to talk to an advisor before you go down that road, just to make sure you've covered off all your bases. And if you are exposed to some risks, that you can mitigate that risk and manage it effectively. Okay. In terms of changing job duties, well, strictly speaking, if an employer makes unilateral and fundamental changes to the terms of an employee's employment, that can be construed, or that could be the basis for a constructive dismissal claim, provided that they're ultimately fundamental. And the employee could resign, accept the breach, and sue you for constructive dismissal and try and claim damages and all the rest of it. Very risky proposition for employees, though, because if you resign and you sue and you lose, you deemed to have resigned, you won't get any severance pay at common law, and you avoid your ability to claim government benefits because government benefits aren't available. Employment insurance and CERB benefits are not available to anyone who's voluntarily left their job. So it's high stakes poker for a lot of employees, and a lot of employees really don't go down that route. They more likely to hire a lawyer and threaten to sue for constructive dismissal and ask for a whole bunch of severance pay. The best way to protect yourself in that situation is to have employment contracts in place. We talked about this earlier in the segment today, that give you that flexibility, that contractual flexibility. Language along the lines of the employee understands and agrees that the employer may have to modify their job duties from time to time as the needs of the business change and require it. And the employee further hereby understands and agrees that this shall not constitute a constructive dismissal, something like that. It's not a total fail-safe, but it'll go a long way because it shows that the employee was aware of the fact that if the circumstances of the business change and the employer has to make changes to keep the lights on, they could be presented with consolidated job duties, new job duties, different working hours, different working locations, working from home. And it's tougher for employees to say, well, I didn't agree to this. Well, you kind of did, and you understood it could happen. So that's the problem. And I also think employers need to and employees need to recognize that we are in uncharted territory. This is a pandemic. And all the case law and precedents that were handed down in non-pandemic conditions about what constitutes a constructive dismissal and what employees should and shouldn't have to tolerate are not necessarily applicable in this environment. And I think courts, they haven't dealt with it yet, but when they inevitably will be asked to address these types of issues down the road, as some cases then move their way towards hearings and judgments, we'll have sympathy on employers. And I think we'll definitely take into account the fact that employers are doing their best right now to try and keep the lights on, keep their businesses running so they can themselves live and pay their bills, but also continue to employ employees and give them a livelihood. We can't forget that 95 to 90, over 90, 92, 93% of businesses, if I can recall my Statistics Canada figures when I last checked them, are small businesses. They are the lifeblood of the economy. We want to keep these businesses going so that we can continue to employ Canadians and give them an income and allow them to live, healthy and economically viable lives. Okay. Um, How long does an employee have to claim constructive dismissal? Good question. The general limitation period is 2 years in Ontario. I'll have to double check in BC and Alberta. Pretty much, I think it's the same in those provinces. Don't quote me. But if you're claiming constructive dismissal, common law, you have 2 years, which is the route most employees take, and that date starts to run the minute you become aware, reasonably became aware of the breach of contract, which from the employee's perspective would be the unilateral and fundamental changes to the terms of their employment. However, just while there's a bit of dead air time here, employees need to be cognizant of the fact, though, that if they wait too long, so if I'm an employer and I make what you would, as an employee, consider to be unilateral and fundamental changes to the terms of your employment, and you're aware of them, and you then continue to work under those terms for a significant period of time without objection. So you don't come to me and say, look, I'm really mad about this. You've making me do all this work that I never signed up for this. And you don't mention anything. You just continue working under the modified terms, and you wake up one day, 60 months later, and say, this is an outrage. I hate this job. Didn't realize it was going to suck this much. I want out of you. This is nonsense. I'm going to sue you. You could run into the problem or the argument by the employer that you've acquiesced. You've never said anything, and you continue doing it for another year. What's the problem? What was I supposed to do? So yes, there is a strict limitation period, but you also have to be careful as an employee that you don't. And this is the employer's advantage. The employee doesn't formally object and say, I've been constructively dismissed, and put their hand up. That they very well may run into an acquiescence argument, which could torpedo the claim as well. Next question. We've had a staff member laid off since December for a holiday shutdown and couldn't return to work when we reopened in February due to having to look after an ill family member. So they've been laid off since then. How would this work in Ontario? Max, so basically the question is, are you as an employer, have you laid this person off too long? Is this now a termination situation, or is it a job abandonment? I mean, look, I don't know all the facts here. I would say this. Here's how layoffs work in Ontario. So employer can lay an employee off if you have the contractual right to do so for a maximum of 13 weeks out of 20 weeks. Okay, so a maximum of 13 weeks in the 20-week period following the date of the layoff if it's unpaid. An employer can lay somebody off for up to 35 weeks, but not 35 weeks, just shy of 35 weeks in a 52-week period. If for the entire duration of that layoff, the employee is receiving some form of compensation, whether it's pay in lieu, benefits continuation, statutory, supplementary employment insurance benefits, and that will suffice. However, if you lay somebody off for longer than those periods permissible under the Employment Standards Act, or if for whatever reason you don't comply with the requirements in the latter case that allow you to lay somebody off for up to 35 weeks, you're in a deemed termination situation. And that employee could then say, you know what, and they may not realize it, but they could turn around and say, wait a minute, I've been dismissed. So I'm entitled to statutory and common law termination and severance pay. Now, again, I don't know all the circumstances involved here. If this employee was not on a layoff, was on some sort of medical leave or disability leave, and put in a benefits claim, for instance, or has gone off on a sickness leave and is collecting federal government benefits, I don't know. That I'm not sure how this has happened. If they went from being laid off to then being on sick leave, whether that would then break up the layoff. I don't have enough facts here to sort it out, but suffice it to say that uh, if you eclipse someone's laid off for longer than permitted by statute, it's a deemed termination. 12:51. Great session today. The questions today have been fantastic, very relevant, and very, I'm sure, helpful for everyone in the audience, and very apt. And I'm not surprised that you are dealing with these as employers. Very difficult and challenging circumstances for everyone. Novel arguments, a lot of novel issues. Um, but we still have 8 more minutes, I guess. So um, please don't be shy. Um, ask away. And to the person who just said thank you, you're extremely welcome. I hope that was helpful, not too scary. And again, if you need help with any of this stuff, don't be shy and reach out to Peninsula, and we can assign somebody, or you can talk to somebody to work through these issues and get some further guidance and some more factual disclosure and get some more specific answers. Okay. Okay. So for those of you who are left, again, ask away. If anyone has any questions, I'm here for another 7 minutes. Um, Next question, what is the procedure to go through to have employees come back that took a voluntary leave of absence? I'm in BC. So when you say voluntary leave of absence, I'm assuming that I don't know if if it's a statutorily protected leave of absence, then employee would have to give you notice that they're coming back and set a return date. The legislation is um, at the moment is enforced for as long as these emergency orders are up and running. But if not, if it's a voluntary leave of absence, I guess that would depend. The return to work protocol or the return protocol would depend on how that was privately arranged between the employer and the employee. So I don't know if there's a contractual term that's being invoked here. So employees there's a provision in the employee's contract that lets them take a voluntary leave of absence, subject to certain terms like length of time and what have you, or whether it was just an impromptu conversation in which employers said, look, you take all the time you need, get yourself sorted, you can come back. It'll be unpaid leave of absence, um, which is fine. Um, but that again would depend on how the leave was taken and in which track, whether it was done with the private consent and approval and the terms with the employer, or whether it was done by some statute or some statutory mechanism. Next question. We usually provide snacks, coffee, and tea to staff. Do we have to suspend that because of the current regulations when we recall staff? Um, I think in the current circumstances, probably wouldn't be a bad idea to, at least until you kind of get a sense of how things are going to play out in the longer term, curtail any kind of practice where employees or people are going to be mingling, sharing um, plates of food or touching mugs and coffee urns or tongs to provide themselves with, to grab cookies and put them on a plate, that sort of thing. That will, and also the message it might send to your staff. Um, they might see that as an indication of there's a crack in the armor, if I can put it that way. Gee, what are these guys? Do we really want to be doing that? And what's our employer doing? Aren't we supposed to be social distancing? We're congregating around a table and having snacks. Um, I think it's a lot. We do that too in our business. I love it. Not now, but before all this happened, we did stuff like that, and staff loved it. It's a great message to your employees that you care about them and give them a free breakfast on a Monday. They love it. I just think now we have to be especially cautious of um, infecting one another, creating risk in the workplace, and that could be the kind of thing that might go down a dark path if we're not careful. Okay, I still got a few more minutes. If anyone has any final or follow-up questions, happy to pick those up before we shut it down for this afternoon. Again, great session today. Love the questions, really relevant, and they've been absolutely fantastic. So ask away. Just not being rude, just checking my phone to see if anyone's um, uh, got back to me or follow up with me on email or text. And a couple more minutes. Um, okay. Uh, Thanks again. Really enjoy these. Thank you. It's not me who makes these, it's you in the audience who asked me the questions. Without your questions, I don't have much to talk about, really. So thanks to all of you. This has been great. Again, the questions today were fabulous. Really, it was a really good session. Um, well, it looks like the queue has slowed down, and we're coming up at 1 o'clock. So we'll see you all again next week. And thank you very much for coming by. And happy to answer all of your questions. I didn't get to any today. Please follow up with us at info@peninsula-ca.com. Please come and see us again next week for another one of our weekly fireside chats. In the meantime, everyone stay safe. Take care. We'll talk to you very soon. Thank you.